All right, thank you for joining me in my very professional meeting that is always very professional with no snafus of any kind. We have joining us Alan Blood. Alan, go ahead and give us our mortgage minute.
Awesome. Perfect. Thanks, Eric. That was very professional.
Was it convincing?
And it sounded legitimate and true. Rang true to me and everyone else that's going to be watching from now and forever. So, conversation I keep having with agents, and I've had this conversation last week with agents that are very seasoned and agents that are brand new. And frankly, was a little surprised that this wasn't more well known and understood. So here's the conversation that I've been having that I want to share with you guys and just give you some information that I hope will be useful for you. If I were to take the last 100 applications that I've taken from clients and look at how many of those people told me their income information, and then it actually turned out that they knew how much money they made, it might be 20%. In other words, about 80% of the time when somebody does a loan application, they really don't know what their income is from what an underwriter is going to see. And I'm talking about people who have W-2 income, people who are salaried, people who are self-employed, all across the board. People give me information on an application that does not match their documents regularly, and not that they're intending to, it's just, they just don't know. And think about it. If somebody asked you, what's your income? You might have a number that is your income in your mind, but is that really what an underwriter is going to see? Is that what you claim on your taxes after depreciation? Do you have other deductions you're not accounting for? And that happens quite regularly. And here's why this is important. If you get a pre-qualification or pre-approval a letter from a lender for a client that you're working with, and they haven't done the extra due diligence to make sure that the information they've been given by the buyer is correct, you may be going on a wild goose chase, or you may be looking at a price range that isn't realistic, or maybe looking for a loan type that isn't going to work once the actual documents come in hand. So here's my recommendation to all agents everywhere. When you're looking with a buyer for a home, or if you're working with the seller and you're going to consider accepting an approval or an offer from a buyer. So the number one question I would ask is, has the buyer completed a full loan application? And you'd be surprised how often I see loan qualification letters sent to people where it turns out that they hadn't even completed a full application. They just had a verbal conversation with somebody and a loan officer issued a pre-qual letter. We don't do that. You shouldn't do it. People do it. So number one, have they completed a full loan application? Number two, have you pulled a full credit report? And the reason why this matters is there's some lenders that are now starting to do what they call a soft credit pull. And the idea is it costs a lot less for the lender to do that. The challenge is if I do a soft credit pull for somebody today, and then they go under contract and want to buy a house 2 weeks from now, and in the meantime, they bought a car, or they charged $10,000 on their credit card, or they did any of a variety of things, or maybe even just new stuff reported that wasn't there, their credit score on that full credit report could have gone down or changed significantly. And that's the one that you have to use for the loan. So if I haven't pulled a full credit report for somebody and I send them out shopping for a house, I don't know that I can get them a loan. So that's the second question. Have you looked at a full credit report for the client? Question number three, have you run that information through an automated underwriting system? For most types of loans, I would say 98% of the loans that your buyers or sellers are going to be looking at, this is conventional, FHA, VA, USDA. There's an automated underwriting system, and there's different systems for those loan types. But there's an automated underwriting system that we run that file through that'll tell us whether the loan is approved. And it takes maybe 2 minutes for me to do that. On a USDA loan, maybe it takes 20 minutes, but it's not a big deal. It's kind of the mortgage equivalent of a CMA, right? It's a baseline setting. And again, very often I'm finding that people are getting pre-qual or pre-approval letters and the lender hasn't taken that step. So have you run the file through an automated underwriting approval system? Did it get approved? And then the last question, have you received and reviewed their income and asset documents? So if they say, yeah, I ran their credit, and yes, I've done the approval, but no, I haven't looked at their income documents yet, you now know that 80% of the time, that approval isn't necessarily accurate, right? So if they haven't received and reviewed their income documents, I really can't tell you if I've got a loan for somebody until I've gone through that whole process. And it's not a tough process to do, right? Like it takes me maybe a couple of hours to do that for a client. But if I'm issuing a pre-qual or pre-approval letter for somebody and I haven't done that, that letter is not worth the paper it's printed on, and it's going to send the client into a situation and you into a time situation that's not going to be useful or beneficial. So those are the questions I would recommend asking anytime you're working with a buyer or anytime you're looking at accepting an offer for a seller. And you might think that those are fairly rudimentary, and you kind of would assume, oh, okay, well, you've got an approval letter from a bank or a credit union or mortgage lender, they must have done their job. Do not assume that. I've seen that a lot lately. When I run credit for somebody, I can see all of the credit reports that have been run for that person for the last 6 months. I can see anybody who's pulled credit. And it's very common that someone will apply for a loan with us and they've maybe made an application with another lender beforehand, or they think they have, and they have a pre-approval letter even. And then we run the credit report and we find out the other lender never even looked at their credit. They were just going off of what the client told them they thought it would be. And then they give you a pre-qualification or pre-approval letter, and then you go and submit an offer and you give that to the seller. And now your credibility is on the line and all of your time and all of that client's time. And we've had a couple of cases where people have gotten pre-approved or pre-qualified, they thought, by another bank, went under contract, couldn't get it done. The agent brought us the file and said, can you help us? And we've had to go in and in some cases completely restructure. And instead of doing a conventional loan, maybe we can get them an FHA loan. And then you've got to go back and convince the seller to do an addendum and all that stuff, or sometimes they just can't do it. And so make sure you've done that extra step of due diligence as an agent. I think it'll save you a lot of hassle and just add a little bit more professionalism in your interactions with your clients so that you can help direct them in the right way. The last piece I would say on that is if you have a conversation with a lender and they've given your client a pre-approval or pre-qualification and they cannot say yes to all 4 of those questions, I wouldn't ask them to fix it. I would go find a new lender. Because if they didn't take that very basic step, that would be the equivalent of you writing an offer for somebody without even looking at a CMA or doing any kind of a comp search. You know, it's just not good professionalism. So if somebody's giving a pre-qual or pre-approval letter to a buyer and they haven't done those 4 things, that's a pretty good sign that they're not detail oriented or taking a really serious professional approach to what they're doing. And that's probably not going to change through the transaction. So that's another way you can kind of gauge what you're dealing with if you work with a lender that you're not familiar. There you go.
Thanks, Alan. I will add this onto that. It is hard to get future referrals from people that have been humiliated because they wanted to get qualified for a loan and couldn't. You know, that you might be able to salvage that situation, but there's a lot of embarrassment there, and people don't like to go back and revisit that. So sometimes it's easier for them to cut ties with you because you didn't save them from that situation. So what Alan's talking about here is a basic, it's a basic thing. It's a concept that applies to both agents and mortgage lenders. And it is, am I brave enough to tell the truth, or am I brave enough to stand up and take the time to do what needs to be done? Okay. And so from a lending perspective, Alan's covered what it takes, because there are a lot of lenders out there that are not brave enough to say, okay, I actually need to get your information, you know, and the client pushes back and says, well, I don't want you to pull my credit because that's going to affect my credit report. Okay, well, I can't give you any real information. I mean, we need to do this. And then you can explain to them, here's how this actually affects your credit report. Here's why it's necessary. But if a lender doesn't say, this is what we've got to have, they're really being weak, and they're not protecting the client, and they're not taking care of them. Agents on the same time have the same problem. You know, people want to go out showing homes without signing an agreement with you, an exclusive buyer broker agreement. And agents, you know, aren't sitting down and they're not doing a buyer presentation. They're not doing the hard things because it's so easy to just send them a hot sheet. Hot sheets don't create any value, you know? So there are things that we need to do to stand up and be bold. Sometimes for sellers, we need to say, here's what needs to be done to your house in order for it to be ready to sell. And if we don't do these things, that's okay. We can still sell your house, but we're going to have to sell it for this much less. Rather than just look at the 3 highest comps, which are easy, and say, hey, here's the 3 highest comps. I can sell your house for, you know, $900,000, when in actuality, it's probably closer to that $700,000 range, because we didn't do the hard thing of saying, here's the issues with the home. They know that their home has issues. They can see the holes in their walls from their teenage kids with anger management issues. You know, they know those things. And quite frankly, when you're direct and honest and upfront and you do the hard things, it makes you stand out. It gives the client a better experience. They know they're not dealing with a pushover, they're dealing with a professional. And so be bold and courageous. and put your client's interest first, even though that's scary, because putting their interest first means that you have boundaries. And the boundaries apply to clients too. You've got to get pre-qualified before we can show you homes. We've got to have this credit report pulled. Okay. Alan, thank you for the Mortgage Minute. And I appreciate you joining us for this deep dive. You're always so good, and I appreciate your feedback. I don't know if you can stay on with us the whole time or not, but you always give us great feedback on the deep dive. Before I get into that, I want to share something with you guys. I have right here. Y'all see that? $100 check to Riley Kelly. Woohoo! And you're wondering, what did Riley do to earn this money? Well, let me answer that for you. I just Venmo'd her that money less than a half hour ago, by the way. So, but the check is sexier than Venmo, right? So here's what Riley did to earn that money. And all of you could be entered to earn that much money or even more every month this year. Okay, you will notice that I'm scrapping the Monopoly board this year. We've debated about it, but what we're doing is we're working on habits. The market has shifted. Okay, I'm glad you like that, Riley. We are moving into a world where agents need their good habits again, and we lost those in the last couple of years. You took a listing, you didn't have to do any work to sell it. If you had a buyer, didn't matter how much work you did, you couldn't get them a home. You know, we're writing 20 offers for one buyer to go under contract. We have been in a twilight zone real estate world, and now we're getting back to reality. And quite frankly, that's a good thing. Okay, getting back to a world where we get to prove our value for buyers and sellers day in and day out is a good thing. So the challenge that we have made for you, and this is, excuse me, this is a part of our 9 o'clock mastermind group. You can be a part of this challenge, whether you are able to join that meeting or not. It doesn't matter. Even if you're just watching this recording, you can join that challenge. Jake has just posted to our Facebook group page. And if you're watching this and you're not in my office, sorry, this is a challenge that's only available to my agents. I'm going to be saving this video. We're recording it to YouTube later. But this is something that goes to my agents. So if you go to our closed group Facebook page, there is a challenge. And Jake, did you pin it to the top like we did before? If you can, pin it to the top.
I'll do that.
Okay. And you go into stick.com, stickk.com. Jake will have all the instructions for you there. And you join this challenge, and it tells you exactly what you need to do. But it's very simple, and it's based on habits, and it's the habits that will make you money this year. And the challenge is this: 10 contacts a day. Well, you get into your contact management software, you do 10 contacts a day, and you do 1 appointment a week. Even if that appointment is a role play to your mom or your sister or your best friend, if you didn't get a legitimate client-based appointment, that's okay. You're going to communicate your value to somebody this week. All right. So practice your buyer presentation, practice your listing presentation. If you can't get it with an actual client, then you're going to do it with a friend or a family member, and they're going to know that this is important to you. They're going to refer you out. So 10 contacts a day, working out of your database, setting 1 appointment a week. However, the prize money is a minimum of $100 because there is a stick associated with this challenge. There's a carrot and a stick. The stick is that you have to join this stick.com. This is how we're tracking it. You're going to report there every week. You don't have to get onto this call. You don't have to be a part of the mastermind group or call, but you do have to get on and report on stick.com. It's a simple website you go in and sign up for, and you're going to say, yes, I did this work this week. I did it every day this week. If you did it every day, great. If you didn't do it every day, $20 a week stick. So you put your credit card in, it'll charge $20 a week. So there's your stick. Carrot is potentially $100. It could be more than that.
We're just 5 days a week though, right?
What's that?
5 days a week,
5 days a week. Yep.
not every
So,
day.
Monday through Friday. If you want to take a break, one of those days, you can work Saturday if you want, you work Sunday, I don't care. But I'm holding you accountable 5 days a week that you're doing those goals. And if you can do that, then you'll be entered into the drawing for a minimum of $100. If everybody does it, then I'm coming up with $100 cash. Okay. But if people are failing and they're putting in $20 a week, that could go up to a couple $100, and that all goes to the winner. All right. So that's how this works. And hopefully lots of people will participate, because really the goal here is to help you build your habits. All right. It's a fun way to do it. There's prizes available at the end for everybody. Doesn't matter your production level. It's a yes or no. Did I do the work this week? Okay. So let's get on with our deep dive this week. So I've got to. Okay. The first thing that I want to share with you, do y'all see the MLS here?
Yes.
Okay, perfect. First thing that I really want to point out to you is I am excited for this, because finally we have the exclusive right to sell listing agreement and agency disclosure addendum. Yay. This means every price change that you do, you used to have me, the principal broker. So for the entire state, every price change any agent does is being sent to me, and I have to sign off, because it used to say principal broker. That didn't make any sense. You didn't even have to have the principal broker signature on the original listing agreement. Why would I have to sign every addendum? And yet that's what it said. And you know how much we trust the Division of Real Estate to look at common sense. They don't. So we've got the form changed. Now the authorized seller's agent or broker can sign this. Now, who is authorized? Every one of you are officially authorized to sign an addendum to your listing agreement. All right, that's good news. So now you can do price changes with your clients. You've got it in writing from them, because they're signing this as well. And, you know, if you need to extend your listing, you know, renew it, extend it out, whatever, you can do all of that, and you can sign this. So you don't need to push that to me to use signatures. Now, this brings up an important concept here. We were just talking about this morning. Rachel brought it up. She actually got seller's disclosures on the old disclosure form. Folks, that's somebody using, that was another agent from a different brokerage, using forms that are months old. How does that happen? It happens because for ease of use, that agent saved it to their desktop. Don't save forms to your desktop. Okay. Fill out your forms from the MLS. It's easy to do. If you're in a part of the state where you don't have the Wasatch Front MLS, that's okay. You can go to .loop, and those forms there will be updated to some extent. But I want to point something out to you here, because it's your job to make sure those forms are updated. It's not .loop's job. It's not SkySlope's job. So for example, if I go over here to, all right, I'm going to have to go back here to SkySlope. Log in this way. All right, if I go to SkySlope and I look for this addendum, give me just a second. Here's all my test forms that I use for these deep dives. If I scroll down to the bottom, you'll notice that I've got an addendum to the exclusive right to sell. I'll show you the first one. So this is called Addendum to the Exclusive Right to Sell Listing Agreement 1-UAR. And you'll scroll down and look, it's this current version, revised 2/21/23. But you know what else is on here? So if I did a search in SkySlope for the forms, look at this, Addendum to the Exclusive Right to Sell Listing Agreement. This is the old form, revised 3 years ago. They're both on SkySlope. But wait, there's more. Do I sound like that late night TV guy selling you stuff?
Yes.
Look at this one. Exclusive right to sell listing agreement addendum 3. We got 3 different versions on SkySlope. Which one should you use? Well, again, we scroll down to the bottom. This one's 3 years old. So which one should you be using?
The one on MLS or on .loop?
These are all on the MLS. So your job is to know that I need to use the most current version. And so if you pulled this up and you saw 3 of these here, like I did when I pulled this up yesterday, I want to scroll down to the bottom and look and see which one is the most current version. Because why do I have 3 different addendum to the exclusive right to sell listing? See, look right here at the name, addendum to the exclusive right to sell listing agreement. Here, addendum to the exclusive right to sell listing. These are the same forms, guys. It's just 2 of them, and they're still here in SkySlope, which is what the MLS is providing to us. 2 of them are not the current versions. Make sure that you're using the current version of the forms. That is your job. It's not SkySlope's job. It's not the MLS's job. It's not .loop's job. It's your job to make sure that you're using the current versions. I would imagine that these older forms will go away in time, but they're still there. If you just went to the MLS, to the forms, to the legacy library, all you see is the older version. All right. And they've updated it. And the nice thing about that is they flag it in red so that you know it's been updated. So anytime you're wondering, if you take my training, then hopefully you adhere to my discipline of going in and studying your forms every single week. For me, it's every Monday. I go in, I either study the forms or I study state law. And I'll do that for a half hour to an hour every week. So with that said, we're going to jump into a deep dive today. And now that we're aware of where the forms are at, how we look and see and make sure that we're using the most current version, we're going to jump over to SkySlope because I like how it pulls it up so that you guys can see everything that we're talking about. And it has been a while since we have talked about some of the basics of the purchase contract itself. I have some new agents on here. You might not have ever written an offer. Last time we did a deep dive on the purchase contract itself, I think it took us 2 hours and we never got to the end of it. Alan, do you remember that? I think we got to like page 3 or something.
Yeah, maybe page 3.
Maybe page 3. So we're going to jump to the real estate purchase contract. And I'm going to brush over some of the front parts of this contract. We're going to cover everything. I'm not going to dive deep into the first part of it because I do want to cover the last parts of it because there are some very important things. All right. So first of all, starting out, we've got a real estate purchase contract. How many of you guys have this saved on your desktop for ease of use? Trick question. None of you, right? That's the correct answer. None of us have this saved on our desktop for correct use because we're going to be jumping in and filling it out from here to make sure that we always have the most current version. All right, we've got our offer reference date. This is piece of cake up here. We've got the buyer and we've got the seller. How do we know who the seller is?
Who's on title currently?
Okay, how did you check title?
Your title report, usually, if there's a preliminary title report in place.
You can get a preliminary title report. You can get that from a title company. Some of them give you an app to access it. If the home was if it's on the MLS, then usually there's a link. You can click the tax ID number, right? And that will show you who's the record owners of the property. So that's how you can find out who the seller is. And then you've got the buyer. And if this needs to change later on, you can change it with an addendum. So sometimes buyers will change it and they'll say, hey, we want this to be in the family trust name, or Alan will run their credit report. And it turns out we've got to add mom or dad on as a cosigner. We can usually do that later on with an addendum. So if something changes, you can fix it. But the better we can make this, the cleaner it is, because an addendum can always be rejected. So if a seller wants out of a contract and you say, oh, hey, we need to add mom to this so we can get qualified, a seller could reject that addendum and say, nope. And what you don't know is they've got another offer in the wings for $20,000 higher. They don't have
Eric,
to.
if I could interject, when you're putting in the buyer's name, I would recommend, just to make the financing easier, ask the borrower how they sign their name on legal documents.
Yeah.
So if they go by, Ben Smith, and they want to sign their names as Benjamin J. Smith, if you can put the contract and the name they're going to use on legal documents, then it'll match up their loan application and it might save an addendum and extra hassle later.
Great. Thanks, Alan. This is why I love to have you on here, because we get to see things from the lender's perspective, not just because Ben Smith doesn't invalidate the contract at all, doesn't make it illegal at all, but you may create an extra step later on for lending purposes that has nothing to do with legality. So I like having Alan on here from a lender's perspective to add some of those comments.
Another comment, Eric, I would ask also just how they would like to hold title when this is all said and done. If they're going to hold it in some sort of an entity, maybe that hasn't been created yet. However, that is their intention at the end. Then we have a little bit of homework to do. They need to get with their attorney and get those documents created so that they can send them to title and to their lender, right? I worked with clients recently who've swapped entities and and addenda come in, at the end. So,
Yes, usually it is harder to get a loan in the name of an entity than it is in the name of the individual. Because holding an entity responsible for that debt burden is,
oh, right.
if they're paying cash for it, this is a non-issue and you're completely correct. Let's get our ducks in a row. You're paying cash. You want to buy it in a trust or an LLC or whatever. That's great. No issues. But if I'm getting a loan for this and I put down an LLC, how does the lender come after an LLC? And
Gotcha.
so,
You're right.
they may
Like
want to
signer.
do that, but they're going to need to close in their personal name. And then they could put it into a
Yeah,
trust or
I know
something
it.
after the
You're
fact.
right. I apologize.
No, no reason to apologize, because you're right. A lot of people are buying with cash and that totally applies in that case. So earnest money, we're going to collect our earnest money. How much is the standard? Minimum of $1,000, but we'll see 5,000, 20,000. Just understand that there is a pro and a con to this. Okay. The pro is that if I put down, let's say I've got $100,000 earnest money. Is that good for a seller?
It depends on how wishy-washy your seller is and if they want to pay the same amount out in liquidated damages if they default on the contract
Yeah.
or want to walk out.
Guys, this could be potentially serious. And we'll get to that here when we look at the seller's disclosure section. It's pretty easy to get a seller default. All right. If the agent doesn't know what they're doing, you could claim a seller default pretty easy. And so that should be something that you have a very serious, if you see $100,000 coming over and you're the listing agent, you see $100,000 earnest money, you need to have a real serious conversation with your seller before you accept that, because that isn't all good news. That is very serious and the consequences can be very serious. Okay. But if you're the buyer's agent, minimum of $1,000 still gets by, seeing that all day long. But you can definitely go higher. The higher you go, the more likelihood you keep the seller on the straight and narrow as well. Okay. Because the penalties for breach of contract are typically, when I say typically, easy 90% of the time. Okay. If not more. The penalties for breach is returning the earnest money at an equivalent amount in liquidated damages. So we saw a lot in the last few years where sellers breached. They couldn't find another home. They had another offer that was higher that they wanted to take. There needs to be a penalty for a seller breach of contract that keeps the seller stuck to this contract. All right. So consider that when you're thinking of your earnest money. Then the last thing that I want you to notice here is that the earnest money is received by the brokerage, and we have 4 days to deposit that into our brokerage trust account. So let's see. First of all, there's 4 calendar days to get the earnest money to the brokerage. The brokerage has 4 more days to deposit that earnest money. Now, Equity has the policy that we hold earnest money with title. One of the nice things about that is when we deliver it to title, it isn't 4 days later you find out if that check cleared. You find out immediately. So that's nice. But we've got lots of reasons why we hold it with title, and I'm not going to go into that right now. Bottom line is, we're Equity right now we're one of the largest, I think we're the 30th largest company in the country. We're in 22 states right now. Utah is the only one that makes it a standard practice to hold earnest money in the brokerage trust account. Other states look at us and say, that's insane. How do you protect your clients? Well, we didn't do it to protect our clients. We did it to make it easy to release. Now, which one will stand the test of time? Quite frankly, I don't think Utah's policy will. I think it will change over time. But again, I'm not going to go down that rabbit hole right now. All right, next we've got the property here. Now, Alan, you've got a trick where I might be able to get an appraisal waiver, saving my clients $500, making my offer stronger. What is your trick for putting in the property?
So here's the trick. And this is actually good advice just in general terms. So if your client is doing a conventional loan and putting at least 10% down, they may be eligible for an appraisal waiver, meaning no appraisal would be required for the transaction at all, but it's based on the address. And so when you're going to put the address in, I would recommend going to the county records and pulling up whatever the county shows as the address. So for example, I'm looking at a file right now on a transaction we're helping somebody with on a refinance. And the street on their, what they think their mailing address is 100 East. The county thinks their mailing address is Roland Way. And Roland Way happens to be 100 East, but if the contract says it's 100 East, that's what we're going to use for the application. That's what's going to show up on the appraisal. That's what we're going to try and use for the insurance. But that may not be the actual address the county uses. And if you use the county's address, you're more likely to get an appraisal waiver because that's the address that's the public record address. That's the one that Fannie Mae and Freddie Mac will use in these appraisal management systems. And so if you can use the address that is on the county records, it will, number one, save you a step of maybe having to do an addendum to get the address to match up to all this stuff. But if they're doing a conventional loan, it may trigger an appraisal waiver for that client. And that can, not only save them time, but money. And if you know that in advance, it can actually give you a nice negotiating power on the contract.
Perfect. Thanks, Alan. All right. That's all we'll talk
Thanks, sir.
about on that section. Then we get down to section 1.1. Guys, I got to ask you a question here. All right. In fact, I'm going to stop sharing the screen because I want to quiz you guys on this. We are writing a contract where the buyer's agent, sorry, I need to pull up chat to make sure I'm not missing comments. Oh, Alan, you got it. Good. Thank you. Okay. We're writing up a contract and we've got a property there and, we want to make sure that stove is included. It's a nice Viking gas range. So we want to make sure that stove is included. Do we type that in the included item section? Viking range?
No, you just check mark on the form that they want the stove or refrigerator or washer and dryer, that they're including that.
Okay, thank you. Now, in this case with a range, I don't even have a box to check because you'll notice this language right here, ranges and hoods, they're automatically included.
Right.
Do not get into the habit of duplicating things. You're like, oh, but I wanted to call special attention to it. No, you don't need to call special attention to it because by that same line of thought, what about all the things you didn't call special attention to that are also listed here? Does that mean they can take the toilet because you didn't call special attention to it? What if they did take the toilet? And they said, well, I assumed you didn't want the toilet because up here it says ranges are automatically included, but you put that down here. You see how it just muddies the contract? So I want you to understand how contracts work. Understand that this language is important, that attorneys do read this language. And when you take a different route than what the contract language states, you create opportunities for attorneys to find weak points in your contract and take advantage of you. All right. So make sure you understand what this language is. If I want to include the washers and dryers and the refrigerator, those are things that typically can be taken really easily and moved. Alan, can I get financing in a typical financing situation if a home does not have a range?
No.
Can't. Okay. So you investors out there that are buying houses that have been gutted, they don't have a range, they don't have a toilet, you're typically a cash buyer for that kind of thing because a lender won't loan on that. It's not considered habitable. Can I get a loan on a house if it doesn't have a fridge?
All day.
All day.
Unless the contract says it has to have one.
Yeah. So these things are optional things. I can get a loan on a house without a washer, without a dryer, without a fridge. Okay. But I can't get a loan on a house without a range. It's got to have that to be considered habitable. So don't get in the habit of typing in washer, dryer, fridge, all those types of things. If you're autofilling this from the MLS, it will autofill a lot of those things in there. And you have to actually take the step because, I can fill out a form on the MLS and have it automatically import everything from the listing agreement. I actually may need to go in and take the step to delete some of those things because they're already listed here. Or I'm going to delete them and I'm going to check washer, dryer, refrigerator up here. But if I've got a big list of things here, that does create some lending issues for me. Now, I'll always differ from Alan because Alan will say here, don't list personal property here. We're not lending on personal property. And so you list all this personal property out. We're going to have to add an addendum later on, removing that, saying it's a separate bill of sale, all that crap. Right, Alan?
Well, Eric, in this new contract, what I was going to actually ask and comment on is, couldn't you just check that box below there that says there are additional items conveyed with separate bill of sale, and then you do your separate bill of sale with that? Would that be the way to address that? Because that would be better from a financing perspective.
Yes. So a lot of times, especially when we're dealing with some of these condos that are fully furnished, absolutely. in addition to any boxes checked in this section 1.2 above, as in these things, there are or are not additional items of personal property by a separate written agreement. So if I check there are, then I can include those things. And if the underwriter wants, they can see it right here. They can see that this is part of our negotiation, and they could ask for that list if they want to. Okay, but if we're listing out a whole bunch of stuff right here, then we are creating a future addendum for ourselves where we're going to have to remove all that and do a separate bill of sale anyways. I am a big fan though, if there is a longer, if it's one or two things, they're usually not an issue. All right. If it's a longer list of things, it's almost always an issue with the lender, or when I say lender, I'm talking about the underwriter. Alan doesn't care, you know, he's there to help you get the loan. The underwriter,
Take it all.
yeah, the underwriter is going to pick this apart. So if you have a separate list, the underwriter can ask for that list, and there is a separate form for that where you can just list out all the personal property that's going to be included. All right. So I had an agent call me and they said, hey, clients want to negotiate for all of these things that are outside of this contract. This was just this last week. An agent said they, you know, their buyers and sellers are trying to negotiate these things. And I'm like, you don't need to be involved in that. They can negotiate personal property outside of this transaction. That's not a double contract, has nothing to do with the real estate. That's like a yard sale. Okay. Go and negotiate whatever you want outside of the contract. If it's personal property, what we're talking about here is real property. All right. Then if you want a specific.
Hey, Eric, can I make just a quick comment on that?
Yeah, go ahead.
As a general rule of thumb, if you can pick something up and walk out the door with it, and it's not one of those check boxes in section 1.2, and it's on the contract, there's a really good chance the underwriter is going to require it to be removed from the contract or conveyed with a separate bill of sale. And if it's something that has clear value, so if it's like a house full of furniture, when an underwriter sees that, they're going to say, well, there's real value to this. We want to deal with that in the contract in an appraisal value type of a situation, and it can muddy things a lot. And so from a lending perspective, if you can use that separate bill of sale, it'll simplify your life, particularly if there's, like Eric said, more than one or two things. But anything you put in 1.2 that you can pick up and walk out the door with, you'll probably have to remove at some point during the contract. And you know, I guess that's a negotiating question, right, Eric? That's what you're saying. Is it either negotiate up front or later? Just know that that's what you're gonna have to deal with.
Yeah, the reason why I like having it included here, and I agree, if it's a small thing, you can put it here and it's a simple thing to remove later on with an addendum. Or I can use this checkbox and have a separate list. Either one is totally fine contractually. The thing that's important though is that right up front in your negotiations, buyers and sellers know what we're asking for. Okay, so whether that's a separate thing, but you know, a separate sheet of paper that's included with this, because they do provide us with that. But you don't want to come back after the fact and start asking for a whole bunch of things after you're under contract at a certain price point, because that just drives people crazy. All right, and I'm already taking longer than I wanted to on these things. I want to make sure if you're a realtor that's been around for a long time, this section 1.4, it was interesting when they redid the purchase contract. It's almost like they were playing a joke on us, because they took the same sections and they fixed the wording on them so that if you didn't read it and you filled in the same stuff that you had always done because you've saved the form to your desktop or whatever, if you were in the habit of filling this out and you've been around for a long time, you'll remember when water service was, we had to list all of the things that were included, and everybody would just write in all pertinent to the sell or whatever. They've changed the language in this that says it does include all water rights and shares, if any, that are the legal source for the seller's current culinary water service and irrigation water service. Okay, so they'll be conveyed, otherwise transferred to buyer at closing by applicable deed or legal instruments. So if you're the seller, this is something, you know, and they've got water rights or water shares, then you need to be aware of that. If the seller wants to specifically exclude those, that needs to be specially mentioned. All right. But in the olden days with the old contract, we had to specially mention the things that were included. So if an agent didn't stay up on their knowledge, they were listing all the things that were included here, and they hadn't read the language saying, now we're excluding it. Kind of a cruel trick on the agents that failed to read. All right. This one section I want to make special attention to for the newer agents out here. The purchase price for the property is $500,000. And it can be provided as in sections 2.1a through 2e, basically all the numbers accounted for here. Any amounts shown in sections C and E the new loan and the balance can be changed. Okay, they can be adjusted as necessary by the buyer and the lender, and you don't need an addendum for that. So right now, I'm going in, my client's pre-qualified. Let's say that they decide to, rather than coming up with 20% down, they find out from their lender they can get a great loan with only 10% down. And so they want to change those numbers. That's totally fine. All right. There's no problem in changing C and E because they change the amount that they're going to bring down. There is, however, a problem. Let's see right here. It says buyer may apply for a mortgage loan on terms acceptable to buyer. Let's see attached FHA via loan addendum. If an FHA VA loan applies, you see the attached addendum. We sometimes see people that come in and fill this out and they're not using the attached FHA VA addendum. And later on, so we think it's, the sellers think it's conventional financing. Later on, we find out and we get the FHA VA addendum, and that can create problems. And most times those problems are created because the buyer's agent didn't get their buyer pre-qualified. They didn't talk with the lender. They didn't get the details like Alan said up front. You need to know, is your client going FHA VA? Are they going conventional? What are they doing so that I can fill this loan, this purchase contract out correctly? And you can't fill it out correctly if you haven't had that conversation with them. This next section down here, 2.2, sell of buyer's property. Do they need to sell their property in order to buy this new one? And we're going to look at this language here. Let's see. Any portion of the cash referenced in section, in order to get the loan, or any portion of the cash referenced up here, do they need to sell their previous property or any other property? It doesn't have to be their home. It could be any other property that they have to sell. If so, then we're going to have an attached subject to sell a buyer's property addendum, automatically required with this. So the question is for you, if I look at you all, and then there's some comments I can type in, or I can look at here. So the question for you all is, I'm representing the buyer. Their home is under contract. It's going to close next week. Do I need to check that box? I mean, this is pretty much a done deal. We've cleared financing and appraisal deadlines. Everything's good to go. We're closing in a week. Do I need to check that box that it's subject? And do I need to include the subject to sell a buyer's residence addendum?
Yes, absolutely.
I do.
It's not over till it's recorded.
It's not over till it's over. And anything else, we're going under contract with fraudulent terms. Okay. We've basically lied when we wrote the offer. All right. Monica, let's see. I'm working with clients who've been pre-approved with the lender.
Maybe that doesn't really apply right now, but
Okay.
maybe Alan would have some feedback on it. I don't know, but.
Okay. Let's talk about it here. I'm working with clients who have been pre-approved with a lender. The lender has let me know that they are qualified to purchase the property together or on their own as individuals. Am I okay to write up the agency agreement as husband and or wife instead of simply husband and wife? Just trying to cover my base in case they choose to buy the property as individuals. So you've got two different things. You've got an exclusive buyer broker agreement here. Put them both on there. If you don't know, just put them both on. And then when they actually go to purchase the property, at that point, they should probably have thought about who's buying it. And if it's only one of them, that's fine. Okay.
So it doesn't have to be and, or I could do
No.
and
Yeah.
then, okay. Okay.
Yeah. And if they want to add an addendum later on, for sake of clarification, you can always add an addendum to that exclusive buyer broker agreement very simply.
Okay.
I'll say from a financing perspective, if we've got a loan in process and someone wants to remove a borrower, you can take somebody off of the loan. If you need to add a borrower after you started a transaction, you have to start over.
Tougher.
And
Yeah.
so, that's the part where before they get too deep into it, they gotta make the decision, but on the contract, we don't really care.
Yeah,
So-
before you write the offer, you should have that information. But for your exclusive buyer broker agreement, it's not a big deal. Lender doesn't see the exclusive buyer broker agreement. They don't care.
Sure. Okay. Perfect. Thank you.
All right, you guys all answered section 2.2 correctly. So moving on, we've got a settlement deadline. Now the only thing that I want to mention here is that we use language in real life that isn't contract language. And we need to make sure that we're clear with this. So we say, hey, we're going to go to closing today. I've got a closing today. Do you have a closing today, or do you have a settlement today? And I'm not trying to get you all to change the way you use your wording, because clients wouldn't understand that. We're going to keep telling clients we've got our closing today, right? But what we actually have is settlement. And there is a difference. There are some details in here that matter with this. So settlement occurs only when all of the following have been completed. All right. We've delivered to each other or to the escrow or closing office all documents required by the purchase contract, by the lender, by title insurance, escrow closing offices, by written escrow instructions, or by applicable law. So everything's there. Any money required to be paid is there. All right. So this is settlement. Any money is required to be paid unless under these documents, except for the proceeds of any loan. So if it's a cash buyer, that's got to be there, have been delivered by buyer or seller to the other party or to the escrow office in the form of cash, wire transfer, cashier's check, or whatever. And then closing means that settlement has been completed. The proceeds of a new loan have been delivered, because usually we don't have the proceeds of a loan there at settlement, but we have right here 4 calendar days after settlement to make sure that that loan is there. So if it closed and funded on a Friday and we've got a long 3-day weekend, it's okay. It can fund and record on Tuesday, and we're still within the requirements of the contract. So that's the difference between settlement. The difference between settlement and closing is that closing means that we've gotten settlement is all the money's there, but closing happens if there's a loan. It might take 3 or 4 days for that money to get there. And the applicable closing documents have been recorded in the office of the county recorder. All right. And that all has to take place within 4 days of settlement. So we've got to have all the money from the loan, and it's got to be recorded within 4 days, and then we're good to go. So a lot of times I'll get agents that call me up and say, hey, we signed this yesterday, but they're not giving us possession yet, and we should have possession or whatever. Okay. There's lots of different reasons why agents call and complain. Make sure you understand the contract has 4 days for those things to take place. So if there's a little bit of a delay on the loan, that's not a breach of contract. All right. They've got 4 days to get that resolved. Now, possession, we can do it upon recording or a certain amount of time after recording or a certain amount of days after recording. Here's the important thing to notice here is that there is no box to check that we take possession prior to recording. All right. So I'm going to stop sharing my screen and have a heart to heart with you. Why don't we give possession prior to recording? I'm going to be the buyer's agent, and I'm going to make a good argument for my client. Hey, look, everything is solid. We've gone in, we've closed. You know, the money will be there tomorrow, or the money will be there Monday. You know, we closed on a Friday. The money will be there Monday. My client's coming in from out of town. They don't have anywhere to stay. They've got themselves a couple of dogs, and they're literally living in a truck. And the mom just had a baby. Like, this baby is 2 weeks old. They don't have anywhere to stay. We've signed everything. We're good to go. Neighbors are lined up to help us move, and we're living in a truck. Can we please take possession today?
Don't do it.
Oh, you're
Excuse me.
so
now,
heartless.
I know, but I've also had situations where something has happened, an act of God or whatever, and the closing, the recording did not take place, and the sellers are out, the buyers are in, and then you have to go through eviction and everything else if it doesn't fund. And
Let's list something.
I have allowed, under doing an addendum and doing a charge, that they have sellers have allowed the buyers to put their belongings in a garage, but not take possession of the house.
Okay, let's list
strict-
some things. Joe,
Okay.
I completely agree with you. Let's list some things that can go wrong. All right. Alan, have we ever seen a bank go out of business?
Yeah, on Friday.
Yeah. Back after 08, they were
And like 15 a day back in 2011. But
Oh,
there was
absolutely.
a major lender that just closed their doors on Friday. So it's kind of starting again.
guys, we could close a deal, like literally go in and sign closing papers, wake up the next day expecting it to fund and record, and instead we get a notice that the bank has gone out of business and they're starting over at square one with a new lender. I saw that happen.
Yeah.
What else could happen? I'm moving the piano in. I'm the buyers. I'm moving the piano in. I slip and fall on a patch of ice. Whose insurance covers that?
The sellers.
Okay. So let's look at all the things that could possibly go wrong. Is any of this in favor of the seller? Any of it?
No.
None. And so, yes, we want to be kind-hearted, but as the agent, is it our job to be kind? No, it's not. It's our job to protect our clients. Now, if our clients choose to do that, that's up to them. But we're going to have a conversation and we're going to document it in writing. If I have a conversation with my client, I'm going to say, okay, this is against my advice. I'm going to actually give you an email saying, hey, per our conversation, I've advised you not to do these things, because we can never advise somebody to do it. We can't. It would be against our fiduciary duty, knowingly putting them at risk. So I'm going to have a conversation. If they say, you know what, I trust these guys. I think they're pretty solid. Look at that little baby. It's so cute. You know, and the neighbors are so excited to meet them. We've told all the neighbors about them. So we're going to put them in. I'm going to say, okay, I'm going to follow this up with an email saying this is against my advice. And you guys acknowledge that before I let people do this. All right. It is not our job to control our clients. It's not our decision to make. It is our responsibility to educate our clients. Here's all the things that could go wrong. None of it is in your favor. And we might want to be the bad guy for a weekend. Okay.
Well, or give them a phone number to a few local hotels. That's pretty cheap for.
They can find their own phone numbers. You're right. Yeah, you're right. So
Maybe
guys,
that's what I would suggest.
sometimes your fiduciary duty makes you the bad guy. It's okay. What isn't okay is you being too kind, not understanding fiduciary duty, ill-advising your clients, and having them experience $20,000 loss. And then they come back to you with their attorney saying, why did you do this? Is this industry standard? And then they're going to call somebody like me as an expert in court. And I'm going to say, no, this is not industry standard. We don't ever give possession prior to closing as defined by contract, not as what we all say, hey, I'm going to closing. Okay. We don't give possession prior to closing. There's not even an option for it in the contract. All right, going back, sharing my screen, because I tend to go off on tangents that, like I said, this is our deep dive. We go down rabbit holes here. All right, I am going to, for the sake of time and for the sake of this video, because we're going down all these rabbit holes, I'm going to jump over certain parts. I know that this isn't what you guys want to see. You want to be here with me for hours and hours today, but I'm gonna stop for a minute on seller's disclosures because we already hinted at this. I am the listing agent, and I just got an offer with $100,000 earnest money. Woohoo! These guys are serious. This is awesome. This is so good for my sellers, right? Well, I've got a seller disclosure deadline. Let's say that they gave me 2 days to get seller's disclosures. Seller's disclosures isn't the written property condition disclosure for the property completely signed and dated by the seller. All right. Maybe I'm a great agent and I got that done right up front. Right. As soon as I met with them at the listing presentation, I gave them the seller's disclosures. They filled it out. I've got that. It's stored in my loop. Piece of cake. Right. Sorry, I've got to send a call along. But I haven't met my seller disclosure burden yet. My sellers haven't met their seller disclosure burden. Okay, if the home was built prior to 78, need a lead-based paint disclosure. I need the commitment for title insurance as referenced in section 6.1. Let's go to 6.1. Okay. It'll be, let's see, at closing by a general warranty deed. Buyer does agree to accept title permits. Okay, so let's see, I'm going to represent the seller as fee title property will convey marketable title at closing by a general warranty deed. All right. This isn't my little PR report, my quick, simple PR report that I asked from the title company to see who the owner is. Okay. This is as evidenced by let's see. Yeah. As referenced here in 6.1, I've got to actually have the title report. Okay. CC&Rs, these can take a while to get. a copy of the recent minutes, budget, and financial statements for that HOA. If there's any leases affecting the property, property management agreements affecting the property. You remember how we talked about water rights and water shares up there on page 1? I've got to have evidence of those. So if I'm the listing agent here, have I done all of this work? If I haven't done all of this work and they've put down $100,000 earnest money and given me 2 days to get them the seller's disclosures, is my client going to default?
Yes.
Yeah. Yeah. So I might actually need to counter offer this and give me an extended seller disclosure deadline and just say, hey, I'm working on this stuff, but I don't have it yet. I'm not going to be able to meet that in 2 days. And if I don't meet it in 2 days, that's a breach of contract. Okay. So you need to understand that sellers disclosures are way more than just what's written in A. And you got to be working hard. The minute they sign that listing agreement, you got to be working hard to get these different things, and you got to have them all ready to go, because usually we don't get a lot of time to provide sellers disclosures. And if you don't get a lot of time, then you need to be aware of that and actually counter offer that contract. They might give you everything else that you want. It's the right price. Everything else looks great. But if you don't have time to meet this, then you're putting your clients at risk. All right, we move on. Let's see, due diligence. I'm not going to go into a ton of detail on these things because I really want to get to a couple of the things at the end here. All right, I'm going to talk really quick about section 10.2. All right, buyers purchasing the property in its as-is condition without expressed or implied warranties of any kind. They have, during their due diligence, as referenced in section 8.1, an opportunity to completely inspect and evaluate the condition of the property. And we're going to jump up and look at 8.1. And by the way, I would encourage you, when you read contracts, if you haven't read them in a lot of detail, do bounce around. If it says referenced here, jump up and refresh yourself. So as referenced in section 8.1, it's any other tests, evaluations, verifications deemed appropriate by the buyer, such as the physical condition, existence of hazardous substances, environmental issues, geological conditions, the square footage or acreage of the land or improvement, the condition of the roof, walls, foundation, plumbing, electrical, mechanical, heating, anything that they want to do. All right. Location of property lines, regulation, use restrictions. You know, can I use this property for what I want to use it for? Is it in violation currently of any of these things? I get to verify all the HOA stuff, even convicted sex offenders residing in proximity to the property, and any other matters deemed material to the buyer in making a decision to purchase the property. What is this language, deemed material? It means, I'm going to look at you all, anything material is anything that could affect the buyer's decision to buy the property or the value that they associate with that property. All right, that's material information that a seller needs to provide. Okay, that's the definition of material, not necessarily, oh, here's something that's hard, it's material. That's not what we're talking about when we talk about material information. It's anything that could affect the value of the property or the decision of the buyers to buy the property. And all of that gets to be verified by that buyer, and the seller has an obligation to disclose any material information as well. All right, so that's what we're talking about when we're down here at condition of the property. They've got a chance to do any types of inspections that they want. And if based on the buyer's due diligence, they elect to proceed with the purchase of the property, then they're relying wholly on the buyer's own judgment and that of any contractors or inspectors engaged by the buyer to review, evaluate, and inspect the property. This survives closing. So if you get lawsuits later on, which we always do, saying, hey, we didn't know this stuff, it was their job to know it. It's our job, and where we get in trouble is if we didn't disclose material information that we knew. That's why it's so important to have those sellers' disclosures filled out correctly. It's why it's important for us. We've added the new form, which is the seller property disclosure confirmation form, as a required part of all our packets, making sure that we're not having sidebar conversations with our sellers.
Eric,
Yeah.
I have a question. I know in Utah, we don't have to disclose a death on the property,
Correct.
but there are some groups who, because of their religious beliefs have difficulty if there's been a death on the property.
Doesn't matter,
So
don't care.
how do we handle that?
Doesn't matter, don't care. Here's why
Okay.
I'm being so rude with that, because state law has defined it for us. There's the stigmatized property statute that says, I don't care what your personal feelings are, these are not material. All right. And so that are things like that. A death occurred on the property. Previous occupant had HIV or COVID, other contagious disease, you know, I mean, we know that that stuff doesn't transmit via properties, so that
Right,
have to be disclosed. That's not material. Suicide, felonies. You know, I bought a home where the guy, I got it from the bank, and I didn't know until I moved in there that the guy had molested half the kids in the neighborhood. They didn't have to disclose that to me, right? And my
Right.
spouse was like, holy crap, there's a really bad energy in this house, and whatever. Some people subscribe to that. I don't, you know, but whatever, some people do. Doesn't matter whether she felt that way and I felt differently. The law specifically says this is not a material fact that needs to be disclosed. All right.
Okay.
And it even goes so far, and this is the one that really gets people, with meth homes. So
right.
if it was a meth lab, they were making meth and they got caught, went to prison, and an investor picked it up and flipped the home and cleaned it all up and got it certified as decontaminated. And that's not his Home Depot test kit. That's, he got it certified, you know, the county came out, they ran their tests, certified it as decontaminated. He doesn't have to disclose that. And that is specifically defined by law as being immaterial, not material. Okay.
Okay.
And neither
Yeah.
the client nor the agent can disclose it. And it's very important to understand that if you're one of those religious people that says, I think this needs to be disclosed, I don't care what the law says, then you need to leave my brokerage before you close that deal, because I don't want that lawsuit. You take that
No,
lawsuit
no.
to one of my competitors, I'll refer you to the competitor I dislike the most, and you can bring them down with you for your religious convictions, but don't bring me down.
No, So in addition to that, then what if the buyer going around talking to neighbors or whatever finds out information that they're uncomfortable with, but yet we don't have to disclose it because it's not against our laws?
Oh, they will.
And
They
then
will.
back
It'll be the
out
very
during their
first.
due diligence. What do you
It'll be
do
the-
then?
It'll be the very first conversation the buyers have with their neighbors. So you bought the meth home. What? Oh, wait,
Yeah.
it was a
Oh,
meth.
you're right.
You know, that's going to be the very first conversation. You bought the drug home. Hope you got a good deal. And so I do think it's part of our fiduciary duty as the listing agent to have that conversation with our seller and say, hey, here's what the law is. There's a stigmatized property statute. We don't have to disclose this. You may want to, even though you don't have to, because we've got all the documentation. We can include this documentation in our seller's disclosures. Again, we don't have to because it's not required. It's specifically not required by law, but we may want to anyways, because we don't want to deal with the headache after the fact. And I've had that conversation with sellers, and the sellers have said, okay, I think that's a good idea. Let's disclose it. And I've had that conversation with investors, and they said, nope, I understand the law. I'm not going to disclose it. I think it will negatively affect my value. And I am confident in my work. We've got it cleaned. I put a lot of money into this. I'm revitalizing the neighborhood. There's no reason I should take a hit on my value. And I'm like, okay, that's the law. We don't have to disclose it. And so I do agree with you, Joe. It's a good conversation to have with your clients and make sure that they understand this could come back after the fact to bite you, but it won't necessarily bite you, but we may have a little bit of a fight on our hands, but the law is also on our side. Okay. So anyways, that's important to understand. Now I want to get down here to a couple of things that we always miss at the end when we get into these deep dives. And I'm already, I'm going to give myself a little bit more time because we had a great mortgage minute with Alan, but there's a couple of things that I want to make sure that we're aware of. First of all, we're going to get down to the default sections. If the buyer defaults, the seller has 3 different remedies that they can choose. They can cancel the purchase contract and get the earnest money as liquidated damages. Liquidated damages mean you take that and you go your merry way and you don't come after anything else. Okay. So in this case, it's nice to have a little bit more earnest money as liquidated damages. That's good. Or they have the option to keep the earnest money deposit in trust, meaning they don't get it, and they sue the buyer to specifically enforce the real estate purchase contract. Now, I haven't personally seen this before, because suing a buyer if they can't perform for some reason, judges, I've never seen a judge do that. But it is an option that they can do. Or they can return the earnest money. So the seller can return the earnest money to the buyer and go after other remedies available at law. And usually what that equates to is actual damages. Okay, now where I could have actual damages that are greater than earnest money, if there's only $1,000 earnest money and the buyer's defaulted. I saw one where the buyer defaulted the day of closing. They didn't tell the seller that they were going to default. They just didn't show up. Seller went in, closed, thought everything was good. Buyer defaulted. Seller had moved. And then they had a couple of months of mortgage payments. And so they had actual damages in the tens of thousands of dollars, and the earnest money was only $1,000. And they sued and they won. Okay, because they had experienced actual damages that were much greater than the earnest money. So they went after the actual damages instead. So if you've got buyers that are treating this contract flippantly, they need to understand there could be some specific remedies under the law that are much more damaging than their $1,000 earnest money. They don't just get to say, well, we'll just give them the $1,000 and walk. They could potentially be held to much more. Now, when we get to seller default, which we have seen in recent years, we've seen more of this happening. The buyer also has those same remedies. They can cancel the contract and get their earnest money back and an equivalent amount as liquidated damages, a sum equal to the earnest money deposit. So the seller could be on that hook. And so this is where, again, as a buyer, if I can come up with more earnest money, it's a strong discouragement to that seller canceling on me, because, maybe I don't want to spend $40,000. By the way, when I tell you that a seller successfully sued a buyer for damages, it was $40,000 in attorney's fees, and that was spread out over 2 years. So don't ever treat a lawsuit as a flippant, easy solution. It is never easy. Okay, $40,000 in attorney's fees for less than, I think it was around $10,000, $15,000 in actual damages. And in this case, the judge awarded attorney's fees to the seller as well. And going further, the attorney was able to find property that buyer owned and put a lien on that property. Most of the time, you'll win a judgment and you won't get any money because they don't have any money to give you. In this case, the seller found a property to put a lien on and threatened foreclosure, and so they actually paid that money. That is the best case scenario you could possibly have, and it almost never works out that way. So keeping clients out of court is by far the preference. All right, it's not easy we never want to say, well, you can just go to court and sue them. That doesn't solve hardly anything, doesn't get our clients money in most every situation. All right, so liquidated damages, that's one of the options. We can keep the earnest money in trust and sue the seller to perform. Maybe they decided that they were going to sell to somebody else because they got another offer for $20,000 higher. Well, we could get an attorney involved, and an attorney could file a notice of interest on that property. We don't do that, but an attorney could. They could file a notice of interest on that property, go to court. They can stop that property from being sold. And so sometimes we do get sellers saying, we'll just give them their earnest money back. It's $1,000 or $5,000, and we're going to make $20,000 more by going with this other buyer. That's, again, not necessarily how this could work out. They could very easily get an attorney and stop that sell, and that sell will be halted until that's resolved in court, which again could be years. So contracts are serious things, folks. We don't treat them lightly. Or the seller, if the seller defaults, then they could get their earnest money back and again pursue other remedies available at law. And if we read that, if buyer elects to accept liquidated damages, then the seller agrees to pay those liquidated damages to the buyer upon demand. And again, that term liquidated means they're taking this and they're moving on and not going after anything else. Okay. And then we've got this special section in here that does allow attorney's fees to be awarded. So we can't just sue people for stupid stuff and walk away. I mean, we could have not only the cost of the lawsuit, but we could have to pay their attorney's fees for, going there anyways, and that survives closing for going to court. All right, this is the section that I wanted to talk about, really. Notices. All throughout the contract, all throughout our addenda, we have things that reference notices. Buyer shall give notice, written notice to the seller. Seller shall give written notice to the buyer. That is, we're defining that in the contract, what a written notice means. And so all notices required under the REPC must be in writing, signed by the buyer or seller giving the notice, and received by the buyer or seller or their agent or their brokerage firm no later than the applicable date. And so our UAR attorneys did a great thing a couple of years ago, because most of these notices didn't exist. It would call for a notice and we were making stuff up. So now I want to show you this. If I jump over to the MLS and I just type in notice up here in the search bar, I've got a whole bunch of notices that I can do. Buyer's notice of cancellation, buyer's notice of withdrawal of offer or counteroffer, removal of conditions, which is the time clause notice, termination of buyer's third-party contract, all of those things that require notice, we now have forms for. So I want to make sure that you're aware of those and are using those correctly. In fact, I just had I'm not going to call it an argument, but I had a good discussion with a broker from another company, called me up. I was at dinner with my kids last week, and I know that I never hear from this broker unless it's a problem with one of my agents. I've dealt with him multiple times before. And he called me up and he says, I think your agent's made a mistake and we're under contract with them, and yet they've accepted an offer from somebody else. And I called my agent and she was freaking out, and I could tell she was worried about it. And I was at dinner. I'm like, let me get back. And I told my kids as soon as we got home, guys, you're going to have to give me a few minutes. I've got to take care of this. This is one of those things that doesn't matter that it's after my 6 o'clock deadline. Nobody's sleeping tonight if we don't get this figured out. So called up the agent, pulled up the loop. And this is why I love good agents, guys, is because they're using the tools that we're providing them with. I was able to pull up the loop, see the contract right there, call up the other broker and say, did you notice this language? It requires a notice. And you say that you've gotten a text from my agent. I said, that text could be interpreted several different ways, but this language in the contract requires a notice. And nobody is going to say that that text was in writing, signed by the buyer or seller, and received by the other party. It doesn't meet that burden. And he says, you know what, you're right. It says my agent's wrong on this, you're right, and I'll go deal with it. And so I was able to call back my agent. They were able to have some peace and go to bed not worrying that they had done something wrong and possibly jeopardized their client and themselves in the process. So this language matters. I'm not going to cover the no assignment. We're going to jump down to time is of the essence. All right. All the deadlines are 5 p.m. So if you didn't understand this and you said, oh, I've got a due diligence deadline of Monday. And in fact, this just came up this morning. One of our agents in the mastermind group didn't get the seller's disclosures until 10 p.m. that night. That's technically a breach of contract. Okay, that's a default up here. And if the buyers wanted, they could get their earnest money back, make some money off of that guy, and then go on and buy another house. Right? And there would be nobody that could argue against that. Clearly, they missed their 5 p.m. deadline. All right, these things matter. The last thing that I want to cover is acceptance. They've got it here in bold. Acceptance occurs only when all of the following have occurred. Seller or buyer has signed the offer or counteroffer, and they've communicated to the other party that it has been signed. So I'm going to stop sharing here. All right, guys, you're the listing agent, and I call you up and I say, you know what? We're under contract. I'm so excited. We just signed at my client's dining table. It's 10 o'clock at night. I'll get you the contract in the morning. Are we under contract or not?
Not till it's been accepted.
No, we signed acceptance. I'm the, that we've offered, countered offered, whatever. 10 o'clock at night, I call you up and I say, we've signed acceptance. We're under contract. I'll get you the contract in the morning. Are we under contract or not?
Not till it's been received by all parties.
Okay, any opposing views?
I don't think they're under contract yet. They need to have it in an email, not a phone call. Because then it's in writing, correct?
Signed and communicated constitutes under contract.
I'm going to go back here because this is different than notices, and agents mess this up all the time. By the way, both of you guys that commented, I just want to be clear. You guys are great agents and you've been doing this for a long time. And I think that's a great example for all of us that your answers were wrong, but I love you and you are good agents. I know you both. You're good agents. And this is how easy this is to not understand. Okay. Notices have to be in writing, signed by the buyer or seller, and received. Acceptance, signed, communicated. So let's say that I signed it and I emailed it to you. Am I under contract? I did not call you. I did not text you. I didn't have any interaction with you. I signed it, emailed it. Are we under contract?
Not until
No.
the seller.
I'm not, because it
until
hasn't been communicated. Me simply sending an email does not constitute communication, does
Cause
it?
I'm asleep and I didn't read the email yet.
Yeah. Yeah. So
Well,
we're not under contract because we haven't communicated. And so what if we've signed it and I called you 10 o'clock at night? I'm so excited. We're under contract. Or I texted you, congratulations, we're under contract. We just signed it. I'll send you the contract in the morning. And you say, okay, that's great. Looking forward to it. Are we under contract by 10 p.m.
Yes.
tonight?
Yes.
We are.
Yes.
We are, because it's been signed and communicated. It doesn't have to be received for acceptance to occur. It has to be signed and communicated. Now, notices are different. Notices isn't signed and communicated. Notices is signed, sent, and delivered. All right. But I want to make sure you understand that communication means communication. It's not an email. It's not a fax. If you want to go real old school, it has to be communicated. So I'm going to look for a text. I'm going to call and I'm going to text. And I say, can you please acknowledge that you got this message? That's all I need. I don't need an acknowledgement that they got the contract. I need an acknowledgement that they got my message. Hey, we're under contract. I'll get you the copy of it in the morning. Please acknowledge you got this text. If they say received, I'm good to go. We're under contract. Okay. So when we go back to the contract, and I'll go ahead and end here.
Can you repeat the 3 for notices? You said sign.
Okay, the notices section is up here, section 18. It's got to be in writing, signed by the buyer, seller, and received by the other party or their brokerage or firm. Okay. So notices require 3 things: in writing, signed, and received. Acceptance requires 2 things: signed and communicated that it's been signed. And that's it. Okay. The last thing that I'm going to mention here is when we go down to the addendum. Oh, no, that's not it. I want to do the addendum to the purchase contract. This is the last thing that I want to mention. Then we're going to close. It's this language down here. To the extent the terms of this addendum modify or conflict with any provisions of the REPC, including all prior addenda and counteroffers, these terms shall control. All other terms, including all other prior addenda and counteroffers not modified this addendum, shall remain the same. Okay, so I'm coming up here, and let's say that I've gotten an offer at 500,000, and they've asked for A, B, C, and D in, repairs to be done or modifications, and they've asked for closing costs. And I'm fine with everything except for C and D. Right? So we've got 5. Oops, sorry, I need to delete. I can't delete it. It's not letting me mess it. Just not letting me change stuff. Where'd it go? Oy vey. Okay, here I can. All right, so remember. Oh my goodness, $500,000 offer price, right? These are the terms. They want 10K in concessions, fix A, B, C, D. All right. This is the offer that comes across. We're okay with everything except for C and D. What do I need to say? Do we need to say we accept the $500,000 offer price? We accept the $10,000 concessions. We will fix A and B, but we will not fix C and D. Is that what I need to say, or what do I need to do for this addendum?
I would, what I've done, and I don't know how accurate it is with things that I'm learning that I did wrong. I would put that, counter it with, we would not accept to fix C and D, all other terms and conditions remain in effect.
Okay, and thank you. All I need to do is say this. Seller will fix C and D, or seller will
Not fix it.
I can't remember. Yeah, well, I can't remember my own scenario here. Okay, seller won't fix C and D. That's it. I don't
You
have
don't
to,
have to put all other terms and conditions remain the
Nope.
same.
because that's right here. All of
Okay.
that is all right here. All of the terms of the REPC, including all prior addenda, not modified this, shall remain the same. So I don't need to write it in, do I? Here's why this becomes important. Again, we start setting a precedent with the way we write contracts. So let's, if this was one counter offer back and forth, done, easy. There's not any problems. How many of you seen more than 10 addenda in a file before? Okay, if I set a precedent early on that I'm reiterating everything that I don't need to reiterate, and about addendum number 5, I get tired of doing this because now my addenda are 2 or 3 pages long. And so I say, you know what, I call up my broker and I'm like, this is ridiculous. And your broker's like, why are you doing it that way? You don't have to do it that way. Here's the language of the contract. Just mention the things that you're going to change. And so I switch mid negotiations and I only start mentioning things that I'm going to change. Have I created some potential confusion? Because I've changed the way I'm doing things? I have, right? Potential confusion leads to potential lawsuits. And whether or not I win is up for a judge to decide, or mediators or whatever, but it's costing my client money because I didn't understand that language. I didn't take the time to read that language. So don't get in the habit, just like we talked about with the included items, same thing when we get to those addenda. Don't say things you don't need to say. Make the contract very clear, state the things that you're going to change. Everything else is considered to be accepted. All right. And let's say that I write an offer and I've got 3 addenda. I've got a closing cost addendum. I've got an FHA VA addendum, and I've got a few repairs that I want done. So I've got addendum 1, 2, and 3 along with my offer. And the seller looks at my offer and they says, hey, we like all of this stuff. We like the offer price. We like everything in the real estate purchase contract. We like the FHA VA addendum. We're fine with that loan. We like your closing cost addendum, but we don't want to fix these few things on the property. We're going to sell it as is. Do they accept the purchase contract and addendum 1 and addendum 2 and then counter offer addendum 3?
Yeah.
Yes,
The answer is no. We're going to
no,
count everything. If all of this came over in one offer, they made the offer with addendum 1, 2, and 3, we have to mark counter on everything because all of that offer is considered one piece. We can't accept little pieces of it here and there. That creates confusion. All right. So the way this works is if I make an offer and it's got 3 addenda, if I don't agree with anything in that addenda, I'm checking counter offer on the purchase contract, counter offer on addendum 1, counter offer on addendum 2, counter offer on addendum 3. I provide them with addendum 4 that says we're not going to make these repairs listed in addendum 3. That's it. But I've countered everything because their offer is one giant piece. I can't accept pieces of an offer. I have to either accept the whole thing or counter the whole thing. Does that make sense to everybody?
yes. I have a question for you.
Yeah.
Yeah.
If there are multiple counter offers, do you recommend or not to, let's say there are 10, your example, counter offers, to do on a final, just to clear everything up, to do a summary of the actual parts of the contract that are accepted by all parties, or no?
First of all, I've never seen anybody get to 10 just counter offering. To me, that's a huge breakdown in communication.
Right,
What we
right,
see,
but
what we see 10 is, you know, we're a month and a half into it. They've had financing issues. They've asked for extensions, you know, they've had repairs and, you know, all of those other things. There's been a whole bunch of things after we went under contract. That's when we start to see 10. Usually we'll see 3 or 4 addenda counter offering back and forth, and then we're under contract. That then stands alone. that contract does. And then any addenda to that, we're attempting to add to that contract. And that's where those numbers get up. So we shouldn't see a situation where we have to do a giant summary because we've just gone back and forth so much. If there's so many things to go back and forth with, make a call to the other agent, say, hey, here's what we're thinking. I would like to have a concise addendum when I put this together, rather than going back and forth over all of these different things, because the lenders, underwriters, Alan, you can speak for this. Let's say that we're negotiating repairs and I list A, B, C, D, E, F, G. And eventually, after going back and forth 5 or 6 times, we agree that we're only going to do A, B, C, and we'll do a small price reduction, and E, F, G can be fixed by the other party. But that's all been negotiated in the contract. The underwriter sees that. What do they say?
Just first of all, don't ever do that. Because as soon as you introduce issues into the contract, you've now notified the underwriter that there's a potential problem. And if they look at those issues and they say, well, we know you don't want to fix the plumbing or the electrical, but we now think those are safety and health issues, so we're going to require those be fixed anyway before we'll fund on this loan because you got a safety and health issue. Or maybe you had an appraisal waiver and those repairs come into play, and because there's now repairs, there's going to be an appraisal trigger requirement. So now you've got to do an appraisal that you didn't have to do before. Or maybe like in a contract that I got last week, you think you're going to be really tricky and you say, well, items number 1, 3, and 5 in the home inspection need to be repaired. Well, you've now just included the home inspection, right, Eric? I just about lost my mind.
Right.
You've now included the home inspection as part of your contract, and the underwriter is going to want to see your home inspection. You do not want the underwriter to see your home inspection. I don't want to see your home inspection.
Yeah.
Right? That's for you. Keep that one private. That's for your buyer. So number 1, I would personally not negotiate repairs in a contract. And if you need to do repairs, I would figure it out back and forth with some conversation, and then do a repair addendum after everybody's agreed to it, or better, just use the resolution of due diligence addendum and get some closing costs or something like that to use instead of the repairs. The other issue you got to know on repairs, since we're talking about it, is anything you put in that addendum that repairs are going to be done must be done, completed, and finished before you can close and fund. You cannot escrow for those items, with very, very few exceptions. And so if you have repairs in there, it's just a big can of worms. So I would personally not, from a financing perspective, a repair addendum is a nightmare. If
So
you can get
let's-
it done with the resolution of due diligence, so much better. I don't know if
Yeah,
Eric, that answers what you're asking.
and-
But yeah,
yeah.
if you are going to have a bunch of stuff, a final addendum clarifying that, the underwriter may require it, but I wouldn't take it upon yourself to do that. I would wait for the lender to say, hey, we want you to clarify these 5 points, and then you can do it, because otherwise you might be guessing what they want and you have to do another one anyway.
So Alan, I just want to be clear to everybody here. We do not endorse double contracts. We do not do double contracts.
Oh yeah, no.
Double contracts is not what we're talking about here. A double contract is defined by the law as, I've got my purchase contract here, but I don't want the lender to see these other things. So we're going to do a separate side contract that the lender's not aware of. We'll take care of these things off the side. There'll be some money under the table, we'll leave $500 under the floor mat. Don't tell anybody. Those are double contracts. That is not what we're talking about here. We're talking about opening lines of communication, and it is 100% okay to call up the other agent and say, hey, we just got our inspection report back. Here's the things that we would like to see. What do you think about these things? And I can even email it to you. Okay. Now, remember, none of this is part of the contract. I'm going to email you this list, A, B, C, D, E, F, G. Let me know, talk with your sellers. Let me know which things you're willing to fix. They come back and say, hey, we're willing to do A. And we email back, say, we really need A, B, C. Okay, we'll do A and B. All right, we'll go ahead with A and B. Now I write it up. All right. I don't have a side contract. What I've had is a side dialogue is all. There are no side contracts. There are no double contracts. All we've done is communicate, and communication is just fine. So we communicate, we come to an agreement. What we've agreed to goes into the contract. What we don't want to do is go back and forth, like Joe said, having 10 different addenda that's confusing to everybody. It messes things up because it goes to the underwriter and they take the negotiating power away from buyers and sellers and say, we don't care what you guys agree on. Plumbing is an issue. You're going to get it fixed before we sell this home. And you call a plumber and they're like, yeah, we're 5 months out. Thanks. But everybody's home is flooding right now. You're not going to get us. This isn't our priority. we've got sewage backing up in all of this entire county. That's our priority right now. You're not going to get a plumber in the home. And yet the underwriter is like, I don't care. Get it fixed. You put it in the contract. We know there's a problem. We're not lending on a home with plumbing problems. And now you've just screwed your deal because you chose to, because you didn't attend this training, right? So none of you guys are going to have that mistake. Anyways,
Hey, Eric, can I ask you a question on this that comes up
Yes,
a
sir.
ton? So let's say you have an addendum and the addendum says the settlement date is going to be X date, the seller is going to pay $2,000 in closing costs, and the seller will pay for a home warranty. And someone counters that and says, the settlement deadline is going to be this date, but they don't address the other two items. When you counter the addendum, is that nullifying all aspects of the addendum, or is that nullifying only the aspects that you specified in your counter? Because I hear this
Only
different
that-
ways from different agents.
only
About the
that date.
clarification.
Only that date. And this is not my opinion. This is the contract language. To the extent the terms of this addendum modify or conflict with any provisions of the REPC, including all prior addenda and counteroffer, these terms control. All other terms, including all prior addenda and counteroffers not modified by this addendum, shall remain the same. It's written right there very clearly that if we countered on those things. And first of all, one of the things that you said is, hey, we want $2,000 in closing costs. Guys, if I ever see you write that, I'm going to be pissed. There's a closing costs addendum. Here's the reason I'm going to be pissed. All right. I'm going to stop sharing and I'm going to ask you guys some things, and we're going over, and I don't care because this is our deep dive and every one of us is learning on here. Okay. You write me an addendum to the contract. You're the buyer's agent and you say seller shall pay up to $5,000 of buyer's closing costs. Let's make it 10,000. Let's make this a good one, right? They're doing a rate buy down. Isn't that what everybody's broadcasting these days, Alan? A stupid rate buy down. They're doing a rate buy down, $10,000 in buyer's closing costs. That's what you wrote in there. And we get to closing, and I'm looking at the settlement statement, and I'm like, whoa, this rate buy down, that's a prepaid. That's not a closing cost. You're prepaying your interest for a couple of years. Can I make that argument? Yeah. Will I win? I don't know. But can I make it? Let's say that, and this does happen all the time. You've negotiated for $10,000 earnest money. Closing costs come up to $5,000. Maybe they've used Alan. I've used Alan before and not had any closing costs, but I've negotiated $10,000 in my closing cost addendum. And then I talked to Alan and he's like, yeah, we're able to do this with $300 in closing costs. What? Really? Yeah. Here's how we did it. It all worked out. Great. Alan, we've had loans like that, right?
Yep.
Okay. So what about that $10,000 I negotiated for?
If you have used the correct form, which is the closing costs addendum, it actually states what you can do with the leftover proceeds if there are some.
But you didn't. You wrote $10,000 closing costs.
Then you should go find a new brokerage and cry in a corner because you're a bad agent.
Yes, you got $300 closing costs. And as the listing agent, I can say, we agreed to pay $10,000 in closing costs. Okay, that's what you said in your addendum. That's it. And yes, I see agents make that argument and I think they'll win every time. However, if you use the actual closing costs addendum, then it can be applied at buyer's discretion toward any or all of the following: permanent reduction or temporary reduction in the mortgage loan interest rate. I can use that to buy things down. Woohoo! Mortgage financing costs. That's my actual closing costs, or from the mortgage closing costs, prepaids and escrows. Any unused portion, I could even use to reduce the purchase price. But if I didn't use the correct addenda and I just wrote seller to pay $5,000 of buyer's closing costs, I don't get any of those other options. My client's going to be pissed at me, and rightly so. Could they come after me and sue me for that $10,000 that they lost? Yeah, they could. Because they're going to call an expert witness and I'm going to be like, yeah, we're supposed to use the standardized forms. This is a form created for all of us. Everybody should know about it. And they didn't use it. And yes, they cost their client $10,000. Pony up. Okay. There's your commission because you didn't attend training. But for those of you that are on here, you're learning. You're not going to pay that life's tuition. All right. So I
have-
appreciate you guys joining me today. We've got a super long recording. I'm